Again, public comment means public comment. Any of y'all out there could actually go submit public comments to this proposed rule. And I recommend, if you feel strongly about it, that you do so.
We are the Armed Attorneys. Today we're talking about a restoration of firearms rights on the federal level. There have been some incredible developments on this, and you won't want to miss it. But before we begin, show your support for the Second Amendment by hitting that like button. And so, all right, just a little brief history lesson, because if you have a federal firearms disability, think convicted felon, think convicted of a misdemeanor crime of domestic violence, maybe there's an avenue for relief for you becoming available. And that's what we're talking about today. It's 18 U.S.C. 925C. I have a bunch of dates written down here, so excuse me for referencing this stuff, but I wanted to give a little bit of background because this is very, very exciting.
This is exciting. This is something that I never thought.
It wasn't on my bingo card.
It was not on my bingo card. I even under, I think we were cautiously optimistic about a Trump 2 and what that would do to firearm rights, but not necessarily through executive order, more through just like telling the ATF to calm down a little bit, which is always helpful. But here we are. Here we
are. I like
are.
how we reference Trump 2 like it's a series of litigation of the same litigants.
I think of it more like the movie titles we come up with.
Oh, yeah. Trump 2, the trumpeting.
The trumpeting.
Sure.
Yeah.
Yep. All right, so going back to this. So we're talking about 18 U.S.C. 925. This is subsection C. This was established in 1968 under the Gun Control Act. And so part of Congress's compromise when they came up with the original list of prohibited people under 18 U.S.C. 922, think G1 felons, right? They said, hey, guess what? We have to come up with a pressure release valve, so to say, so that people can seek to get their firearms rights restored. All right, that's all well and good. Well, in 1972, that kind of department for handling these things, this was originally handled by the Secretary of the Treasury, okay, for whatever reason. But in 1972, this was transferred to the ATF. And for a little while, the ATF was processing these applications. We saw with the Firearm Owner Protection Act in 1986, it was modified a little bit. But here's what happened, and this is why I wrote all these dates down, because I'd never remember it. So in 1992, the Congress passed a rider onto a budget that effectively defunded this rights restoration division. And so, people would submit these applications. Guess what? They wouldn't even receive a response because this office was effectively shut down.
Yes. So I was in elementary school in 1992, so I cannot say this with absolute certainty, but just in my guts, I can almost guarantee that's when the first Democrat started calling this a loophole rather than a compromise.
Yeah.
So, because
today's compromise, you're going to say it?
I was going to say it. No, you say it.
Okay. Well, today's compromise is tomorrow's loophole. I mean, we say that all the time when it comes to lawmaking. And so for the longest period of time, I mean, we're going on 30 years now, this office has not been funded. And so, and there's a corresponding department for, let's say, folks who had, were once deemed mentally defective. Maybe they've regained competency. They're normal functioning members of society. They want to get their gun rights back. I talk to those folks every now and then, and guess what? They weren't getting relief either. So this office wasn't even issuing responses. And we have an interesting Supreme Court case from 2002. This is United States v. Bean. If you want to check it out, 537 U.S. 71. And essentially we had somebody who was saying, hey, guess what? I want to get my gun rights back. I've submitted my materials and application to the ATF. They're not even responding. I'm coming to the court for, judicial relief, effectively, because I can't get it from the executive. And Justice Thomas authored this opinion and said, guess what? Getting denied relief from the executive is a condition precedent to us being able to do anything. And so you kind of have this chicken and the egg scenario where it's like, hey, they won't respond, give me relief. We can't give you relief until they respond. It was terrible. And so, but this is where the new development comes in.
This is where the new development comes in. So this is, and I'm just going to read you Richard's note here because it's very dramatic, but I like it. Enter Donald Trump. Okay. So yes, we have in sort of our very Trump 2 directives to reevaluate what the administration's priorities are on the Second Amendment, which is upholding Bruin and not slashing regulations necessarily. That would make me a lot happier.
Identifying infringements.
Identifying
That
infringements. I
sounds
think that
legalistic.
that might actually be the exact wording that
Okay.
he initially used. So we have a proposed rule to grant relief to these people. And here we go. We have the application for relief from disabilities imposed by federal laws with respect to the acquisition, receipt, transfer, shipment, transportation, or possession of firearms. And this proposed rule was proposed on July 22nd, 2025. It is number 2025-13765. It is open for public comment until October 20th.
Well, and I think the big thing behind this is also they're taking the authority away from the ATF because obviously they cannot be trusted to self-regulate when it comes to these
Sure.
things. The authority's being sent over to the Department of Justice. And I've already seen like a proposed application floating around. It looks a lot like a pardon application. This is not a pardon.
This is not a pardon. You will, should you apply for this rights restoration and be granted this rights restoration, you will still be a convicted felon. However, I think really following in the Rahimi guidelines, right? I think this necessarily follows from Rahimi. They're going to look at you and decide whether or not you can have your federal firearms rights restored despite the outstanding felony conviction, because Rahimi tells us that you have to be dangerous.
Yeah, that's what we get from.
I mean, constitutionally, you have to be dangerous to not have your firearms rights.
Exactly right. So these blanket prohibitions, and we've seen challenges to, let's just use 18 U.S.C. 922 G1, for example, our felons, folks. We've seen challenges all over the country of folks saying, you know, I'm not challenging the broad facial constitutionality of this law, but as applied to me, this is an unconstitutional infringement on my Second Amendment rights. And we've seen success stories all over the country. And so this is one of those things where, all right, we need to get back to fundamentals here. We have to identify these folks who, we'll just use the Rahimi standard because that's what we have to work off of, aren't a danger, right? You know, think of, and I've told this example before, like felony window tint violation out of the state of Tennessee, where you lose all of your gun rights forever because your windows were too dark. That's ridiculous, right? Obviously, those folks shouldn't lose the right to keep and bear arms, defend themselves, their families, all these other things.
Now, if there was like a felony, your bass is up too loud in your car, I don't know about those people. I hate those people.
Sure. Well, you know, all right. Going back to Rahimi just for a second.
Okay.
But the court does, you know, that's really, they uphold the prohibition on Rahimi, and that's that case if you wanted to check that out as it relates to active protective orders. And this guy, Rahimi, bad dude.
Yes.
Bad dude, bad facts, bad law.
Bad law. That case was decided badly. All of you out there who don't want us to talk about Rahimi, go on.
Sure. But all right.
However,
But we kind of get this.
we get this.
We get this dictate almost from Rahimi that we need to come up with the pressure release valve needs to be revived.
Yes. So we have, and I think that it's worth simply reading the summary here of the proposed rule. So the Department of Justice, the department, proposes to implement criteria to guide determinations for granting relief from disabilities imposed by federal laws with respect to the acquisition, receipt, transfer, shipment, transportation, or possession of firearms. In accordance with certain firearm laws and the Second Amendment of the Constitution, the criteria are designed to ensure the fundamental right of the people to keep and bear arms is not unduly infringed, and those granted relief are not likely to act in a manner dangerous to public safety, and that granting such relief would not be contrary to the public interest. So, you know, that's cutting out at the knees right there, all the people who are going to jump into not our comments, the comments on the proposed rule, with, oh my gosh, this is going to wreak havoc on public safety, blood in the streets type, right?
Yeah.
Again, public comment means public comment. Any of y'all out there could actually go submit public comments to this proposed rule. And I recommend, if you feel strongly about it, that you do so, because I mean, we see, gosh, the pistol brace rule, the
Tens of
ghost
thousands.
guns rule, tens of thousands.
Right now,
if
this
not
has like
more.
200 comments.
Yeah, right. I mean,
It's not that sexy of a rule, but
it's not. And you know, I mean, I think, do they pay attention to the public comments? Oftentimes, no. Remember when old Obama wanted to regulate the green tip ammos?
yeah.
That was the outrage through the public comments there made them back down.
Yeah.
They backed down. So, I mean, I think, although not always mission critical, doesn't hurt.
Well, and especially if, and really what I think the best use of comments are isn't like a yes, I like this, or no, I don't like this. It's the deliberative, here's the rule. I foresee this problem, or hey, this is going to be an issue or abused by some government bureaucrat. Those comments are really the best ones because we get, diamonds made under pressure. You get better outcomes in these regulations if there's, productive comments. So,
Absolutely.
think about how are bureaucrats going to sidestep things, if you're reading the rule. I mean, that's the kind of stuff that I'm looking for.
Right.
Now,
So, well, I was going to say, we've got another
Well,
step here in our,
yeah, and this
another
is
hitch in our get along.
right. So, record scratch, that's, but
Sounds great.
yeah, but that's not the end of the story. Because a lot of folks, you have to be aware, because I've already talked to probably a dozen people who are interested in submitting applications under this new proposed program. The program's not open yet. I've heard some lawyers say they've already submitted petitions. I don't know if that's productive or not. I'm going to wait and see what the criteria are before I go firing off a petition. But a restoration under 925C does not automatically restore your rights under state law. So I'll repeat it. You get relief from the federal government. Let's say once this program is active, they say, yep, you get your federal firearms rights back. If you have a felony conviction, most states are still going to say you are prohibited. If we have our own state level prohibition on felons, that prohibition still applies to you. I don't care what the federal government has done. Now, a few states have been super proactive about this. They've written it into their law saying, if you get your federal firearms rights restored under 925C, we automatically treat those as having been restored under state law.
Yeah. Georgia, I think, does that.
Maybe even West Virginia, but this does not exist in, let's say, Texas. Texas, you still have to go to the Board of Pardons and Paroles in order to get your rights restored under state law.
Yes, this is a law that needs to be drafted, pushed, and passed in Texas in the what year of our Lord is this?
2025.
In the 2027. So, we do that pretty well. If anyone needs us to do that. So it really is important, and because it is not something that would currently exist in most states. In most states, great. You got your federal rights back, but now your state's still going to mess with you because you're not pardoned. You still have that conviction.
Right, and just, and this is a note for Texans, part of the way you can help this fight, get this provision passed into Texas law, joining Gun Owners of America here in the state of Texas. We lobby for them. This is one of those things where we see a problem, we need to fix it. So we'll run that up the flagpole, but that's how you can support them, joining GOA. But when you look at how someone applies for a pardon or federal firearms rights restoration in Texas, this has been basically my life for the past couple of months.
Richard's getting into the pardon biz.
Yeah, well, a part of asking for your firearms rights restoration is submitting an application under 925C and just getting a response. They don't care what it is. But for the longest time, the boards kind of waived that provision because they know, hey, guess what? We're not getting a response out of these things. I see that coming back to life in the near future, which is going to complicate pardons in Texas just a little bit. But, I think this overall, very good thing. Still some problems here in Texas. If you are in one of these other states where your state automatically gives you your rights back, fantastic. If you're in Texas, we got work to do.
Yeah, absolutely. But keep an eye on it. I mean, once the rule is final, we're going to have a lot more to say about it. If you live across the country, we can probably point you to good lawyers in your state who can help you with this process.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, leave us a question or a comment below. Until next time, we're the Armed Attorneys.